Ready, start. Criminal Procedure Code 1973, Section 439 in bracket 2. Next, petition for cancellation of bail granted to accused number 1. Attempts made by the accused number 1 to evade the due course of justice. Material on record to show that there was no prospects of securing accused number 1. Material on record to show that by his conduct the accused has put the entire trial in jeopardy. Exercise of the inherent powers of the High Court to compel the accused number 1 to submit to the trial bail granted to accused number 1 is cancelled. Next para, held in bracket A. In the instant case, the circumstances of the case clearly established that the accused has successfully hoodwinked and misled the court to believe that he is engaged in propagation of Hindu religion, but the facts and circumstances of the case clearly indicate that he is not available in India and his whereabouts are not known either to the prosecution or to the persons close to him. Under the said circumstances, there being overwhelming material to show that accused number 1 has misused the liberties granted to him and has run away to a foreign country to escape the trial. Next para, needless to say, purpose of bail is to ensure that the accused person will return for trial if he is released after arrest. If this purpose is defeated by the accused by keeping himself away from the court with impunity and disdain, by keeping himself away from the court with impunity and disdain, and his whereabouts are not known to the person who would naturally have heard him if he had been alive, and the prosecution is handicapped to serve him notice and the prosecution is unable to reach the accused. He would be a sheer mockery of criminal justice for system to allow the accused to be at large with the hope that he would one day return to face trial. Next para. It is now well settled that once bail has been granted, it cannot be cancelled unless there is evidence to show that the conditions of bail are being infringed. The grounds for cancellation of bail broadly are interference or attempt to interfere with the due course of administration of justice, or evasion or attempt to evade the due course of justice, or abuse of the concession granted to the accused in any manner. No doubt, cancellation of bail should not be resorted lightly, but that does not mean that the court cannot ordinarily cancel the bail, especially when the trial is in jeopardy. In the said circumstances, the only course open for the court is to cancel the bail granted to accused number 1.